بسم الله الرحمن الرحيم والصلاة والسلام على رسول الكريم. السلام عليكم ورحمة الله تعالى وبركاته, and welcome to Takaful online class. And today topics is the resolution 42 on the Sharia Advisory Council of Bank Negara that talk about the applications of MUSAHAMAH concept in a commercial general Takaful plan, meaning that whether the concept of MUSAHAMAH could be incorporated in the business model of Takaful or not, meaning that whether the MUSAHAMAH concept could replace the Tabarra contract or not, and even if it doesn't replace, whether the MUSAHAMAH concept could be introduced as an additional business model concurrently with Tabarra. Then, based on that, whether the financial institution or the Takaful operator could subscribe to this model or not. So let's look at the content of the issue or the proposal, then we look at the resolution. So basically, the resolution said that the Takaful company would like to introduce a MUSAHAMAH concept in the commercial general Takaful plan. And under this concept, the Takaful participants will pay contribution to the Takaful company based on the MUSAHAMAH as a benefit. And the Takaful participant may make a claim and receive compensations for any incidents or losses. In the Takaful participant, if the Takaful participants do not make any claims within the effective Takaful tenure, so basically they are entitled to receive a return of contributions in the form of bonus, good experience refunds, subject to the following condition, meaning there are three conditions. So what we're trying to say here, it's a concept of MUSAHAMAH, whereby the participant would be contributed based on MUSAHAMAH. And of course, they would be entitled to receive a compensations or a bonus if there is no incidents, if there is no compensations that has been processed to the respective participant with three conditions. Number one, there is a surplus in Takaful risk fund, meaning there is a surplus to be distributed. Number two, the participant had either made any claim, not received any compensations on a specific period, meaning that within that year, so no claims, no compensations has been exercised. Number three, participants agree to renew Takaful contract for a certain period, meaning they are an agreement to what's called renew the policy. And if the participant did not renew the contract, so the contract will be deemed as an agreed to waive this bonus on the basis of Isqatul Haq, meaning that in case Takaful, the participant does want to renew, so basically the policy typically will be terminated and he will not be entitled for this based on the Isqatul Haq from the side of the participant, meaning the participant waived his right and entitlement for this compensations from the surplus. Now that's the proposal that has been presented, and based on the resolutions and the meeting of the Sharia Advisory Council number 66 that was dated on 22nd February 2007, the SAC has resolved that the applications of the proposals of MUSAHAMAH contract in general Takaful plan is not allowed, which means that the Sharia Advisory Council of the Central Bank did not allow the concept of MUSAHAMAH with the content that has been presented. Now, one of the arguments that has been discussed in these resolutions, among them is that the proposal basically to apply concept in general Takaful plan is not allowed because MUSAHAMAH is a concept with ambiguity meaning. So what they're trying to say here is that MUSAHAMAH is a very has an ambiguity and lack of details, because MUSAHAMAH is a kind of contributions. So it's kind of contributions, but there is no specific underlying determined contract that govern that kind of MUSAHAMAH. So in the context of the current practice of Takaful, we will say it is a contributions. It could be from a literal meaning, same as Musahama, because Musahama or contributions from a literal meaning, they are the same. But the only thing is that the Musahama, the contributions, is to act, to donate. But the underlying contract in the current business model is tabarru. So tabarru is a determined and clear and identified contract that is known in Sharia, which has some terms and conditions, and it has a clarity when it comes to the concept, term and conditions, and the Sharia requirements in order to validate the contract. But the problem here that has been mentioned is that Musahama has been used in both what's so-called meanings, meaning it is a contributions and at the same time it is a contract. And here there is an ambiguity because we cannot identify what do you mean by Musahama, what contract that govern the Musahama concept. Is it a partnership? Because it is a bit close to the partnership as they are going to highlight afterwards. Because the Musahama has the meaning of partnership. So it could be a partnership underlying contract business model of Musharaka, and could be basically nothing as an underlying. Then as a result of that, it will be a very loose meaning. That's why they said that the contract of Musahama has an ambiguity in its meaning because it is a loose, it is a lack of information. What do you mean by Musahama? Is there any specific contract on Musahama? Is there any dispute? So what kind of contract we should refer to in order to resolve the issue? What are the terms and conditions? What are the basic rules that should be applied on this contract? We can't do that. We cannot identify because of the ambiguity and the fragile meaning of the term that has been used. So that's one of the main issues that has been highlighted in the resolution. And also it is an unknown contract in the fiqh al-mu'amalat. So we don't know a contract in fiqh al-mu'amalat called Musahama. Meaning, yes, in the context of some contract, like for example, literal meaning of an actions, an act to donate, even in the tabarru, yes, even in the musharaka, yes, but as a contract, as a technical term for the contract, there is none of a specific contract called Musahama. And the Musahama definition, as stated in the proposal, as has been highlighted in the proposal submitted to the SAC, is inconsistent with the overall features and operation of the Takaful model. So even though it doesn't mean, here we have to highlight a point, it doesn't mean the contract does not exist in Sharia, it is not allowed. That's not the point, because Sharia allowed a known contract to be used in Sharia. So it doesn't mean he has to have a contract, but at least some terms and conditions could be applied to this new term in the what's so-called base and trade based on urf. It's not the what's so-called the main arguments here, but we're trying to say is that there is no specific contract that has been named that you can do a cross-reference to it in order to determine the feature of this contract. And also with the meaning used, it is not consistent. It's not consistent as the other arguments. It's not consistent with the practice of the Takaful operators in the current business model, especially in cases of claims by the Takaful participants. So it's not really consistent with that because tabarru basically is a donation, then the compensation comes. So when it comes to the Musahama, this Musahama is in a form of what? Is it a partnership? Is it a sales? Is it a wadi'a? Is it tabarru? Is it a qard? Is it a waqf? So there is an ambiguity to determine the underlying concept. As a result of that, it may not jive with the current practice of the Takaful. And also on the contrary, Musahama as defined indicates agreements among Takaful participants to give a certain contribution. So it contains an agreement to give compensation to the participant. And by right, in the current business model, there is no such an agreement, because it's a kind of what's so called undertaking by the Takaful operator to do so, because what has been agreed is basically to donate and administer the claim, but there is no such agreements, because if there is a such agreement, it could form what's so called a partnership contract between the two parties. And also they mentioned that the MUSAHAMAH concept was found to be unsuitable in allowing any claims and payments to the rightful participants, since MUSAHAMAH, based on the general definition, is a kind of sharing in order to gain profit. So here they try to make it very close to the partnership contract, to the sharika, because sharika has the MUSAHAMAH concept also, because every sharik, every partner will do MUSAHAMAH with some capital. So the MUSAHAMAH is also related somehow to the partnership because of the contributions. So the contributions, we call it also in Arabic the MUSAHAMAH. So it is also not consistent and applicable and convenient to the structure of the compensations paid to the participants, and it is not meant for donations in paying any claim under the Takaful scheme. So that's the overall descriptions of the resolutions 49 with regards to the application of MUSAHAMAH concept in commercial general Takaful plans. And based on the stand of the SAC, they found that the contract is not convenient and it is not consistent what's so called with the practice of the Takaful operator, and from a Sharia standpoint, it's a bit loose term that has a degree of ambiguity, and it is difficult to determine the underlying contract, to determine the obligations and the responsibility and the Sharia requirements and rules in order to govern the contributions, compensation claim, and so on and so forth. Wallahu ta'ala a'la wa a'lam. See you inshallah in the next session. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.